Good evening to everybody here in India. Good morning to the Western Hemisphere people, and good late evening to the people on the Eastern. Thank you very much. And first of all, Saul and Mr. Pramanik, I think we are delighted that you are with us today. I think the subjects in digital economy are so important, and you have been thought leaders in many ways. So it will be very, very good to hear you. I do not want to cut into your time, but we are very privileged to have you. And, I first of all want to welcome you, and then we'll have more discussion as we go along. So may I tell Parul to take over the charge and moderate the session. And I think Meyyappan, welcome, thank you, all of you. It's wonderful evening, and let's go on. Thank you.
Thank you, Nishith Desai, and very warm welcome to all our participants and also, our special guests for today's session. We've had, 2 or 3 sessions regarding digital taxation as part of our international tax series. But today we are going to discuss, something slightly different. Of course, we'll also talk about, what what seems to be the government's intention to introduce the equalization levy, and our guests would have some views to share on that. But I think probably while we get to equalization levy and significant economic presence, but this question of taxation of digital economy or taxation of digital transactions or the use of technology in order to earn income, whichever way we put it, the same transaction can be talked about in various ways, has actually, bothered the judiciary of our country for the last few years to come, for the last few years. And even, while the issues which surround the taxation of the digital transactions have been at the forefront of the discussions at OECD, which has actually resulted in the, in the BEPS action plans, to which, India has also given its commitment to abide with. But if we really were to look at what has been happening in India, and specifically in the concept of, a virtual taxation or a virtual presence or some sort of, a presence which is there due to use of technology. And, let's look at what really has been happening in the past few years. The concept of virtual or intangible presence is, it can be looked at through various ways. It can be looked at some sort of a presence of a foreign entity in India, which is devoid of any physical presence. But then how would that presence really exist? Would it exist because of, certain user base in India, which is being, which is the whole, crux of the SCP model? Would it be through the use of any equipment which is placed in India and which was looked at, through the MasterCard ruling, or even, some of the Galileo and the Amadeus rulings? Or could it be, due to use of some software in India? We also had a very interesting ruling in the case of Volkswagen, and the bench brought out the whole concept of a virtual or an intangible business connection, something which does not really touch the territory or the shores of India, but is wide enough that it's, it's somewhere there over the cloud in India, or it's in some form, and it's sufficient enough to create a taxable nexus with India. And that's a whole concept which has been bothering not just taxpayers, but also our judiciary. So this concept of virtual or intangible business connection, or some sort of a technology related permanent establishment, it has been touched upon in various rulings. And I won't really talk about all these rulings. I think Maya is going to touch upon those as the session proceeds. But the Morgan Stanley ruling did talk about that the definition of permanent establishment in the Indian context was wide enough to include a software permanent establishment. The Verizon ruling, which was delivered by the High Court of Madras, talked about establishing a virtual PE or a virtual business connection because because certain technology or certain computers were placed in India. And the virtual presence of a taxpayer operates through the equipment which could be placed in a customer's premise. That's the concept which was brought about in 2013. But if we also, look at one of the, cases at the forefront, which dealt with digital transactions. One of those cases was really, the Amadeus case, where computer reservation and distribution systems could be accessed from India, and computers and connectivity provided by the taxpayers was held to result a business connection in India. And this was also relied upon by, by the AAR in 2018 when they decided against MasterCard by, holding its entire network and, the MIPs that were placed in India to establish a permanent establishment of the foreign entity in India. I think very interestingly, also what has happened is that, we've also had cases which have held that the traditional brick and mortar rules of permanent establishment today are not wide enough to capture the virtual, digital economy. And this is what was held in the Wright Flores case in 2013. Interestingly, one of the senior judges of the same bench, brought out the concept of virtual and intangible business connection in the Volkswagen case, just some time back. So in 2013, when India was dealing with the Wright Flores case and, waiting for any change to happen on the digital forefront before India could really put, its right to tax on such transactions. In the same year, OECD also came out with a BEPS plan, and then in 2015, the task force regarding the challenges of the digital economy was released, and India was quick to implement the equalization levy in 2016, followed by the cCep in 2018, and then, of course, in 2020, just a couple of months ago, we saw that there has been another change made to the equalization levy to try to tax online sale of goods and online sale of services. And at the same time, in 2020, we also have the Volkswagen case creating a virtual or an intangible business connection of the taxpayer in India. Or actually, it was not really of the taxpayer, but we'll talk about that, in a bit. So while so much is really happening in India and internationally, there are also a lot of other unilateral changes which different countries are doing in order to tax digital transactions. I think the question that really comes foremost on one's mind is what really is, what really is the government's intent or approach? And the BEPS project started in 2013, and a lot has happened since then. Whether we look at the statutory changes or whether we look at the approach of the judiciary in taxing some of these transactions. And from a professional's perspective or a taxpayer's perspective, the issue that really arises is how do you really examine some of these changes from the perspective of which transactions are really meant to be covered within these, and how do you really deal with those. So I think to answer that, we have Mr. Priyabrata also on on the call with us, and Mr. Priyabrata has he's part of the tax policy group with the Government of India. So my question to you is, Mr. Priyabrata, if you could just give us some insight on what really is the thinking of the government. Where are we headed towards where digital taxation is concerned, and what type of transactions are we really looking at taxing?
Yeah. Sorry for not being on the Webex because of some technical flaw. But anyway, I'm hearing you and I'm very much part of that program. So actually what happened, tax policy research unit was entrusted with the government of India somewhere around 2018 to draw a comprehensive tax policy for digital economy and e-commerce. So we have submitted our report to the government, and that has also been approved first by the CBDT and then by the Ministry of Finance and then by the Cabinet. All have approved that and that has become final. Now, I am just going a little backwards, actually, what we have considered while writing that report. And now government is developing its own policies or legislation based on that report of CPRU. Because that replaces the earlier report of 2016 when some such committee of taxation on e-commerce was formed by CBDT. Because CPRU is directly under the Ministry of Revenue, Government of Revenue. So anyway, so what you have seen in the base report or in the OECD's articles, the challenge was how you frame the laws for taxation of the digital economy, which is quite different in its approach from the brick and mortar economy. So the concept of permanent establishment was basically based on the brick and mortar economy. It was also acknowledged by OECD that we require a paradigm shift in international tax. And based on that paradigm shift, but basically keeping in focus, actually what should be the basis of taxation, it is not your source-based or otherwise. Actually, the concept came from what G20 summit held, that what should be the basis of taxation, that is where economic activities occur and value is created. So the major area of thought was how you define the value creation and who forms the value creation. So there was a deep start even in TPR, even in other government quarters, to find out where this value is created so that we can have a taxation law where we can pinpoint how the value is being created through this global value chain by some MNEs operating, say, in 100 countries. It is not a local problem. It is not an issue of, say, India only, or, say, Africa only, or USA only, or Europe only. You have to pinpoint how this value is created in digital platforms, who is contributing to that value creation at what measure, and how you define this value creation. So our entire research was based on to define the value creation, and in doing so, we found out that this value is not what you find in your balance sheet or profit and loss account, which is apparent on record, but the value is more intangible in nature. So to define an intangible value and to pinpoint it on the taxation, it poses serious challenges. So it took us quite a long time, almost a year, to finish our work, how this value is created, and we submitted more than 100-page report to the government, and pinpointing the areas actually where the government needs to look into. So the subsequent legislation that Government of India has brought in, even something which came as late as on 1st April 2020, in the equalization levy. The issue is based on our report through some research. That is my point. Okay, over to you. Hello.
Yes, thanks. That's quite useful. You talked about where value is really getting created, and that's where the tax should be, and where the intangible really is. And you talked about your report based on which the equalization levy was also introduced. Was there any discussion on and specifically?
Just can I add one thing?
Sure.
Just I am adding one thing. It is not only equalization levy, there were 3 options. In our report, we have suggested 3 options. One is significant economic presence. One is withholding tax on digital transactions. And another is digital equalizing levy or equalization levy. So it is not only on equalization levy. And it should be remembered that equalization levy is a stopgap measure. It is not the final outcome. But we are ultimately aiming for going for the significant economic presence, or APP, as you may say. But yes, for the time being, before some kind of consensus is reached at OECD or other places, we can go for equalization maybe for the time being. Over to you.
Sure, thanks. So you talked about, how there were three options that were given, and and you talked about how it was a kind of a wait and watch, and I guess you're talking about the 2016 year where the EL was introduced for the first time, but it was deliberately not introduced on tangible goods. Specifically considering that the OECD approach had yet to be formulated. And Professor Saul, here I think I'd really like to take your views. When we talk about the OECD unified approach, and there's a whole talk of Pillar 1 probably getting pushed to the next year. A lot of countries are already pushing back on the formulatory approach which is being used in Pillar 1. What are your thoughts on Pillar 1 and Pillar 2, and where do you really see this going this year and probably the next year, and how do you really see countries reacting, and where is this really going to lead us to?
Well, I hope you can hear me now. The position now is, as reported by the OECD in the tax talks, which some of you may have listened to last week, is that obviously in view of this current COVID crisis, it's difficult now for them to achieve what they had intended, which is to deliver a compromise package to the inclusive framework meeting at the beginning of July. That now would only take place as a virtual meeting. And what we understand is that they will aim to get a refocused package to a meeting of the inclusive framework in early October, prior to the meeting of the G20 finance ministers in mid-October. Now, the refocusing is mainly on, is particularly obviously on Pillar 1, and particularly on the amount A and C. So that instead of trying to get the broader agreement on a wide variety of platform services and other kinds of services, they would focus only on highly digitalized companies, essentially to resolve the standoff between countries that have introduced unilateral taxes, and not only India's equalization levy, but obviously now a number of countries have introduced these digital services taxes. And these are obviously are all taxes, gross taxes on payments, and have been treated by the United States. There was a finding by the US Trade Representative that these are discriminatory trade barriers against the French proposal, but obviously the others are on similar lines, so the same reasoning could apply. So the US Trade Representative has authorized retaliatory tariffs. Now it was agreed that they would be withdrawn if agreement could be reached at the OECD. So I think the aim is to reach agreement at least on an alternative method, which could be introduced in lieu of these gross taxes. Now, what form might that take? I think a possible form might be, as included in the recently enacted the UK's digital services tax, although the main tax is on similar lines to that of other countries such as France, gross tax, it does provide a net taxation option to provide particularly for one of the problems of these gross taxes, which obviously disregard the actual profitability of the activity. So it does allow companies to opt for the alternative. So companies that on a global basis are not so highly profitable, this might apply, for example, to companies like Amazon, can opt for the net basis of taxation, which essentially applies a global profit margin to the local revenues. So I would suggest, I would foresee that possibly this is the proposal that might come forward, at least on the amount A, but not for the, as I say, for the broader range of platform services, for a narrower range of highly digitalized activities. In addition to that, I think it's quite likely that something would be agreed, or they're certainly aiming to agree something on amount B, a new method for attributing profit to distribution activities. And then also for Pillar 2, the global anti-base erosion tax. They're aiming to have an agreement on that. So it would still be possibly, I mean, this is their intention, whether that's possible or not. I think it's highly likely some agreement will be reached on the global anti-base erosion tax. I think given the pressures on countries to deal with these problems of the digital services taxes, it's quite possible something might be reached on that. And amount B, I think, is also feasible. But it would obviously be a rather minimal agreement. But it's worth bearing in mind that even the January proposals for the broader Pillar 1 would still firstly, only allocate a relatively small proportion of the profit, only a portion of the non-routine profit. The projections in the economic analysis that the OECD put out were based on an assumption that it will be 20% of non-routine profit might be attributed to market jurisdictions. And also, although the January statement defined the consumer-facing businesses that would be covered more broadly, I think, than the proposals last October. Nevertheless, they significantly excluded B2B services, business-to-business services. Now, I think that is a significant limitation because as much of the litigation in India has shown, these are a significant type of activities. Many of the cases which we might discuss, like the Volkswagen case and so on, are essentially about B2B services. So those would anyway have been excluded. And so even with the slimmed down version, or even if we had a broader version, I think still these efforts under the inclusive framework would not resolve many of these issues. So we're still basically faced with the problem of how to approach the essential problem, which, although on the one hand it's a question of taxable presence, I think more broadly it is a question of allocation of profits. Regardless of the question of presence, the question is how do you tax profits? And one way or another, they're going to be taxed either on a gross basis, as I say, through equalization levy, through digital services taxes, or I would have thought that companies would prefer to be taxed on a net basis, which takes into account the profitability of the company itself.
Thanks, Professor Saul. And I think this, your comments regarding companies preferring to be taxed on net basis is pretty relevant because in the Indian context, with the equalization levy does not really look at net profits or gross profits. It's just a tax on the transaction, and there is no opportunity to either use carry forward losses or to argue a lower allocation and so on and so forth. But probably that's something which the government would have thought about as an interim kind of a levy till the time OECD's proposals are not acceptable. But Maya, I think my question to you, considering what is happening globally now, the OECD work is going to get pushed to the next year. US has already given its indication that it does not like the formulatory approach. India also has reservations, and US is the country where most of the tech giants are based, whereas India is the country where the market is based. So on both ends of the the table, you're seeing that the countries may not really agree with that, and so much is left to be seen for next year, which means that a lot of the things that we have seen through judicial precedents or through statutory amendments do really look like they're here to stay for some time. So my question to you is that if consensus seems likely to be delayed, then how do you really look at the source concept being expanded? How do you really look at India, taxing these transactions, and what has happened till now? Maybe you can just throw some light on the past, the present, and the future.
Sure. Thanks for all the for setting a stage, Parul, and for giving information Saul and Mr. Priyabrata. I think to quickly talk about what are the cases that have happened in the past, and rightly, as everybody said, I think the context is that increasingly there is going to be lack of consensus. For a couple of years already, India has been actively taking steps to impose new taxes. They expanded the GST regime to cover online services being provided from abroad a couple of years back. And we've had the equalization levy, we've had the introduction of significant economic presence in the domestic law, and even on transfer pricing, we've seen interim reports, not by the CBDT but by an expert committee talking about increased attribution based on user contributions being presented last year. So in this large, in terms of trend forecasting, I think on the legislative side, clearly there is some concerted action to think about these issues and bring about legislative changes which are increasing the right of India to tax digital transactions as a source country more comprehensively. But what's also developing in parallel is that these issues are being agitated under current laws before courts, and which sometimes results in positions which are quite different from what I think what the global discussions are at, and or what the thinking behind the introduction of new taxes would be at a policy level in India. So to quickly deal with some of the rulings that have come on these aspects, right? First of all, I think some of the cases Parul had already mentioned. One of the earlier cases that talks about software permanent establishment was the Morgan Stanley case. And these are all not rulings exactly on the topic, but rather the observations by courts in light of a changing context when they are dealing with cases that deal with software or technology as one of the aspects in their case. So the second case that where we can talk about virtual PE or server PE is cargo community case, which basically was involved this offering of services through a server located outside of India, which was accessible through a website or a portal in India. Now, in these litigation cases, typically the stance that is taken up is that it is business income and therefore not taxable without the permanent establishment in India. However, so what that ends up in resulting is sometimes court make a finding that it is a royalty income and therefore subject to tax. And in some cases, they have used the words or referred to a virtual presence and adverted to certain other facts to try and establish them. So in the cargo community case, it was actually held to be royalty, but they did kind of address the arguments was raised that it's a mere website in India and therefore not taxable. And in fact, India's own reservations to the OECD model convention recently state that a website is not a PE except when there is significant economic presence, except in cases where it would constitute a significant economic presence. So the court made some observations where they said that the portal and the server are indistinguishable, and that if you're accessing the portal, it's as good as you're accessing the server, and then proceeded to construe that as royalty. That was followed by a case in Amadeus Global and Galileo. This was the software ticketing system that Parul had referred to. This case has been subsequently relied on in the MasterCard case, which came about last year. So what this case dealt with is, and this starts the trend of looking at a fixed place permanent establishment using a technology lens and seeing what are the different thresholds which were traditionally required for constituting a fixed place PE, and how they have been kind of watered down in the digital context, right, or progressively interpreted in this particular context. So the four tests that the court looked at was the disposal test, whether there is a place of business, whether there is a business activity that is being conducted which is not auxiliary or preparatory, and what is the permanency of that fixed place of business, right? These are the four tests that the court looked at, and the fact pattern was that there was a ticketing software which was accessible through terminals installed in the ticketing agent's office in India. And these terminals sometimes, one of the restrictions around the terminals is that they could not be moved around except without the permission of the offshore party. So looking at these 4 tests, they said that yes, this is at the disposal of the foreign party, because the restriction that you cannot move the terminal around was sufficient to make a finding that it was at the disposal of the foreign party. It was clearly a place of business, that the machine or the terminal was a place of business according to the court. And they also said because ticketing is the main source of revenue, it is not an auxiliary or preparatory activity. And while the court didn't get into the nitty-gritties of the permanency requirement, they said that a computer system that is there in a particular office would be considered sufficiently permanent if we go by the findings, ultimate findings of the ruling. So using these principles, effectively we have come down to what was probably considered for a fixed larger sort of equipment. We have found that courts have accepted if a laptop or a computer, so to say, is in a particular place and at the disposal of a foreign entity because of these additional tests, courts are willing to find that it is actually a permanent, fixed place permanent establishment. Now, if we were to go forward with the next case, which is Verizon, which again was dealing with certain services being provided to Indian taxpayers, and the question was whether those broadband or the services being provided were royalty payments or not. Now, one of the factual aspects of that case was that in providing those services, the modem or the equipment was actually being installed in the taxpayer's home, or in the offices in India by an offshore party, which was under, you could say that it was under the control in a way of the offshore party. Now, the court, of course, makes a finding that this is royalty because they go into whether the servers in India, which also are part of the process, are under the control of the foreign party or not, and establish that it's a royalty payment. But they established the royalty payment also because the bandwidth was dedicated to a particular taxpayer, and that's why it was considered royalty. But some of the interesting observations there again related to the reference to virtual presence of the SSC in India through the software and other technology that they use, and the recognition that the law has to be interpreted in that context. But again, it was obiter, it was observations that didn't directly impact the ruling, but there was a reference there to virtual presence again. Now, 2 other cases where there was actually a direct sort of a ruling, and one is, of course, we are focusing on case laws right now, which have looked at an expansive interpretation of the source concept of taxation. But I would like to highlight one case which reiterated the old position, or the position that without a permanent establishment as traditionally constituted, income cannot be taxable. That position was reiterated in the Wright Flores case, where Indian party was making payments to an offshore digital service provider, search engine provider, Yahoo in this case, and that income of Yahoo was held to be non-taxable because there was no PE in India. And as Parul said, to come back when we are looking at judicial trends, I will come back to this case because the judge who authored this case as 7 years down the line now looked at it from a very different perspective, probably when it comes to the Intangible Business Connection case. So coming to one case specifically on virtual presence is the ABBFZ ruling, where it was under the India-Dubai Treaty, and there were services being rendered in India by personnel or employees of the foreign company who stayed in India for 15 days each. And while the service continued for a good part of the year, more than 9 months period. So the court rejected arguments, where the taxpayer said that the service PE clause was not triggered because the employees have actually not physically stayed in India for more than 9 months. But the court negated those arguments and stated that it doesn't matter how long they are physically present here. In a digital age, what matters is whether the services have been rendered for more than a 9-month period, right? So that's probably where they actually have directly ruled upon something that could constitute a virtual presence, although they don't use that language there. We then move on to the MasterCard ruling, which again takes us back to how the concept developed in the Amadeus and Galileo rulings, on the CRS equipment or a computer constituting fixed place PE has actually been further developed in a way where the MasterCard ruling goes in to look at MIP. So MIP is basically a MasterCard interface processor. They described it to be the size of a standard personal computer, and it is placed at customer locations in India. It was the intent behind the MIP was that it should be able to facilitate authorization, clearing, and settlement of payment transactions. Now, the way the structure of MasterCard worked was that the Singapore MasterCard company had a subsidiary in India, and all of this equipment, including the MIP, cables, and other devices that are referred to, were owned by the MasterCard Indian entity. But when we looked at the case, the court has gone into who exercises part of the ownership controls. There are observations in the case which suggest that some of these devices could be repaired or could be replaced only on the instruction or with the permission of the foreign party. So therefore, they vested ownership rights with the Singapore company, and later went on to find that these cables and devices and a personal computer-sized machine or equipment was sufficient to constitute fixed place PE in India. Of course, the case also talks about agency PE, but that's not relevant to our discussion, so we are not going to get into that. So keeping this in mind, the trend clearly has been between all of these judgments to lower the threshold for presence in India, both under fixed place PE requirements and under service PE requirements. And before I get into the intangible business connection case, I think it's important for me to point out that a lot of these case laws that we are referring to are not final. They are not Supreme Court judgments. These are judgments by several tribunals and high courts who have made observations. So that's just a qualifier I wanted everybody to keep in mind. But it nevertheless shows that judicial trend is increasingly coming up with these sort of opinions on these aspects. Now, the last case I'll be quickly dealing with before I hand it over to Parul is the intangible business connection case. Now, this is a case where a foreign actor was engaged by an Indian company in India for an event that is occurring outside of India. So basically, the event happened to be in Dubai. A lot of the Indian agents or sellers for the car, Volkswagen car, they were flown down to Dubai, and this foreign actor performed at that event outside of India. It was part of the agreement that the performance of the foreign actor could be recorded for marketing purposes at a later point in time through internet or other medium. And at all points in time, the intent behind the event was to either directly target, at a later stage when the videos were uploaded on the internet, to target users or customers in India. And at the initial stage, it was to market for an Indian audience who were flown from India to a location outside of India. So in that context, the court goes on to hold that the income paid to the foreign actor constitutes income taxable in India because the event was an India-focused event, and that was sufficient to constitute business connection. So while all the previous cases talked about a foreign party having a presence in India through a virtual PE, this case takes it a step further in terms of what we look at from a source taxation perspective, and lays that even if an event happens outside of India under domestic law, that would constitute a business connection. Back to you, Parul.
Yeah, thanks a lot, Maya. I think that was a very good summary of a lot of Indian decisions which impact virtual business connection or virtual PE in India. Nishith, I just would love to get your 2 bites on this.
Yes, I've been listening with a lot of interest because this discussion has nostalgic memories. 15, 20 years ago, I was involved in Amadeus and Galileo cases. At that point of time, the main case that was being pointed out was the vending machine case, old one. And that's how the whole thing had started. And since then, we have seen a lot of interesting cases done in Brett Street and many, many other ones relating to e-commerce and digital issues that are coming up. And what I'm trying to ask Saul and also our friend Pramanik, how do we solve this issue? Because are we some expressions are being used more commonly these days called value creation. Now, first of all, let us understand what is value. Is value same thing as a price? The way in which I would define the terms would be price is a function of demand and supply. Value is a matter of perception. So once you get into value, it is going to create a lot of problem because what is most valuable to me may be completely invaluable to somebody else. Okay. Therefore, it is this concepts of value, they are more like, cosmic connection or platonic love and whatever you call it, it's very difficult to figure out what exactly it is and what value and what price will put it in terms, because ultimately tax has to be paid in actual money terms. And the countries will have to reconcile in many ways. And I think a lot of efforts are being made. But as has been mentioned, that we have not really defined base, or at least we have not come to a conclusion what is base. Each country is likely to encroach on the taxing sovereignty of other country. And therefore, in some ways, one would say that there could be expansionist or what I call tax imperialism that may also grow, because each country is starved of revenue, and therefore everyone will try to tax it. But where is the taxpayer left? Because the same transaction, one country would say, here is a connection, whether virtual or otherwise, and therefore I am entitled to tax. Other country will say, no, here is a value creation, and this is how I would like to tax. And taxpayers are completely at bay, So we have to find some solution. And at the same time, we'll have to really draw out the framework. My gut feel is that it is going to be very difficult, not only for taxpayers, but also for tax administrators. Because if the tax administrator doesn't, doesn't imagine the way in which somebody else, his successor may imagine that, oh, it should have been treated like this, merely based on perceived connection, he could be held up after retirement, so it is creating trouble for everybody. And really speaking, are we going to solve the new age problems through the old instruments or old tools, how are we going to fix them? And we really need to come together and find some solution. Of course, I have spoken 1,000 times, so my views on one world, one taxation. But at least what we are trying to say is that, if countries can come together and find some solution, it is better. As far as taxpayer is concerned, why are you bothering him to go to 100 countries and fight cases on which are being, imposed on him on a perception basis, So idea is that, okay, if countries at least could come together, give one formula, and deposit that tax in a global depository or custodian, and with branches in different parts of the world, they are held in custody, and the countries can sort out as to how we want to distribute. So first of all, you can have faster collection mechanism. Taxpayer doesn't have to fight into many countries. If 130 countries come together and they figure out who should distribute what. And number three, that do we need to completely rethink the way in which we have thought of income tax all these years, because time has come to figure out whether this is going to solve problems or it is going to really create more problems and more complications and more, issues for the whole world. Because in perception world, it's going to be very complicated. So I think it is better that, some formula is worked out, some bases are indicated based on which taxpayer is told, and you will say, okay, what is reasonable tax? Okay, if you think 15%, 20%, at one point of time, it can be, paid. And anyway, BEPS and others are talking about single entity concept and, global look through and whatever it is, So you're going towards that. It is better that we recognize this issue and rethink the whole basis on which we put income tax. And, at least assure the taxpayers one thing, that you will not be taxed twice. That much right, at least we have to confer on the taxpayer. because today I think is completely torn apart, because one country would tax, recover tax, and then second country would say I would not give a tax credit. Just as in the case of equalization levy, US said that we are not going to give a tax credit for equalization levy. Now, how do you manage those ones? So if you can, at least nobody minds paying some tax, okay, fine. But if it is double, non-taxation is not acceptable, double taxation should also not be acceptable, and uh, it works both ways. So if we can find some ways, that would be very helpful. And but most important thing is if you want to continue with income tax, then so most important thing is a, 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 a concurrence amongst all the countries as to what is base, what basis you are taxing, and now if I don't know where it is and how OECD thinks about it, but or India thinks about it, but let us do some design thinking and solve problems both for the taxpayer and for the taxing countries. I think that would be a wonderful way to move forward. Otherwise, what else the solution is? If this solution is not okay, fine, let's find some other solution. But is there some solution, or we'll continue to fight as old states and countries continuously fought for small territories at one point of time? Now I think world is much better, less, you know. So if there's some thought, that would be very helpful. At least India could be a leader in initiating some of these concepts. So I don't know.
Can I contribute now?
Yeah.
Professor Saurabh, just turning to you. Your comments.
I think, Nishith, you absolutely hit the nail on the head. We do need a solution, and we need a comprehensive solution. And I think it's fairly clear now that the only comprehensive solution that would ensure neither double taxation nor double non-taxation should be a global approach, which should be a formulary apportionment approach. And I think here India has taken a lead and has got, I think, proposals together with the G24 group of developing countries, which I think should be the only basis on which we can get the kind of solution that you've been arguing for. Because we've seen that the other approaches really are unsatisfactory. Whether they're withholding taxes on the gross amount of payments, or even if you find a PE, if you're still having to attribute profit to that PE, or even to the group of entities that are found to have a taxable presence in a country, there's still the question of attribution of profit. So that's the central question. And that, in fact, was called for by the G20 leaders when they mandated the BEPS project. In the St. Petersburg Declaration, they asked for the BEPS project to result in reforms that would tax where economic activities take place and value is created. And that's the concept that you asked. What does it mean, value creation? And I entirely agree with you again that value creation is too subjective, too vague. My interpretation is that they put that in because if you say, well, you should tax where activities take place, that assumes a fairly physical notion of activities. And I think there's the feeling that the activities may have different levels of contribution to the gross profit. So the question is how you consider the nature of the activities in each country as contributing to profit. And I think here again, the paper by the G24 group and also the very helpful paper by the CBDT in putting forward its own proposals for fractional apportionment are very helpful there, because what they argue is that the apportionment factors should be a balance of production factors and consumption factors. Now, the argument for that, I think there are two basic arguments. That if you're saying value, clearly production-based factors generate value, whether it's actual physical production, manufacturing activities, or research and development, those kinds of production side activities, capital invested. But it's fine to have all those activities, but unless you can sell the product, you don't generate profit. So the balance of production and consumption factors, I think, would be a fair approach to allocation of profit. The other element of that is, and this is the main argument put against a formulary approach, is could countries ever agree? Now, I think there you have to consider what is the what are the factors countries should take into account in deciding on the formula. And there, I think you have to accept that it's not only a matter of the tax revenues. Surely, from a point of view of tax revenues, countries would say, well, countries that have a high labor endowment would say, well, we want to emphasize employment factor. Countries that have high research activities would say, well, it's the intangible contribution. Countries that are mainly markets may say markets. But it's not only revenue. As we found in tax treaties, countries are also highly concerned in allocation of taxing rights on the impact on investment. And a country that has high labor endowments, like India, or for that matter, China, may, from a revenue point of view, want to emphasize the employment factor, but that would discourage inward investment. If you attribute taxing rights based on employment and you're a high employment-based country, then that would encourage investors to invest elsewhere, to create jobs in other countries. So if you take account of both the investment impact and the tax revenue impact, a balanced formula would be the way forward. So I would say that India's taking a lead, not only in the measures that we've talked about, the attempts to tax on a source basis, but I think now in putting forward these proposals. And I think that is the way forward. The debate now really is about whether that could be done unilaterally. Now, it seems to me that a unilateral approach based on a formula would be preferable, and maybe to many companies would be preferable to these unilateral measures based on gross taxes on revenue, on payments or on revenues. They would be moderate proposals, and some arguments are being made that they could even be introduced on the unilateral basis. There are questions then about interpretation of tax treaties and Article 9. I'm happy to go into that if you like. I think Article 9 has been much misunderstood. It certainly doesn't require the transactional-based approach in the OECD transfer pricing guidelines. And I think even a formulary approach could be considered compatible with Article 9, which asks for outcomes comparable to those of independent firms. So I would say the way forward should be, for the solution you've asked for, Nishith, should be a formulary apportionment approach. And I think we need support from a number of countries, but also from business, because that will be the only way to provide certainty and predictability for business.
If I may just add one thing here, again, it's a very off-the-cuff thought, that today there is huge disparity in the world, economic disparity, right? And some countries are extremely rich, some countries are extremely poor. And just as when we have one country, like federal, country, and you have states and they've got the center, right? And you distribute revenue sometimes not only on the basis of what revenue is allocated, apportionable to the one state or the other, you also take into account the economic condition. Now, some point in time, we will also have to think that, even if, for example, in the example I was giving, if total revenue is collected in the global depository, and then some 70-80% revenue can go to the country where source or whatever it is, but 20-30% should also be shared with other countries. And so it is something like GST or VAT kind of a arrangement in a federal setting, and some way to find a balance based on the economic development or otherwise, because everyone contributes somewhere on the line. For example, you look at the supply chain. Okay, today you are trying to break it up, but I think even though the contribution of one country theoretically maybe or practically maybe is very small looking, but if that chain is weak, the whole supply chain breaks off, right? Now, who is responsible for pandemic, right? This has all happened. Now, one would say, no, because of China this happened and because of somebody else it happened. Okay. Now, who has created value, but who has destroyed the value? Okay. So I'm saying that if we can think on a global basis, just like people think of the whole country, maybe whole United States, which is, in my view, most ununited states of America. Okay. So you got certain taxes collected at federal level, certain apportion to the state. Same way in India, at federal level, you collect tax and then apportion in GST kind of thing. Because the entire basis of income tax will have to undergo change also. I do not know where would this game end if we are going to look at the value creation, as I was mentioning in my previous talks, that new technologies are going to create lot many new problems, including, for example, AR, VR. So augmented reality, virtual reality, one individual or one company can be present in multiple places at the same time. So, how will you apportion and how will you allocate? So I can give a talk which is broadcasted to the whole world, okay? And, you know, I'm talking on the video today, and it will be virtual reality otherwise. Now, each country will say, look here there was, you gave a talk. So this is, you created value from my country. Other country will say, I got 100 countries, we get 100 countries joining, on this kind of video. And you don't know, today you are talking from the UK maybe, and, now you are adding value, okay? Now, should that value be taxed on a dimmed basis, because you are now, your reputation, your brand, your other thing has increased in India with this video. I would not suggest tax department tax you for coming on this video, but there can be a lot of theories you can build around, and I don't know how it will end up. So really we need to go back to drawing board today before whole situation becomes out of hand, and countries will fight, and companies will, and the taxpayers will be torn apart in number of different jurisdictions. I think, Mr. Pramanik, maybe you might have some thoughts, generally on a broader basis. We need to solve problem of everybody.
Actually, what Mr. Desai has pointed out, and Saul has also spoken on that, is a very, very vital point, that how do you measure the value creation? What has been stated by the G20, that your taxation should be done where value is created. Now, problem is that we have already measured that. We have already applied certain formulas. We have done some economic modeling. We have done some econophysics modeling. How this value is created, but there is a huge lot of equations, graphs, etc. So this may not be the forum. And the problem is government has not made that entire report public. It is not in the public domain. I would have liked that I could discuss in the public domain, circulate the report for everyone to see and comment on that, the kind of research that we have done, and we have pinpointed where this value is created. So that will answer your question, Mr. Desai, that how do you measure the value creation? So we have already done that. But I am just giving you some hallmarks of that study on which the government is now doing this legislation, and new legislations have come up. So basically the value is created on the contribution of data. User content data, the internet that is being used by the users, they are not only using it, but they are also contributing their personal characteristics in social media and many other forums. So their personal characteristics are being captured and analyzed through algorithms, through artificial intelligence. And this whole bunch of users, they are creating a virtual platform through some kind of network effect. That is increasing the value. So there are a lot of equations. I am not going into that. But this is basically the platform under which the digital economy throughout the globe is operating. So this network effect, when it reaches some sort of critical mass, then actually your any goods or services lost through digital platform reaches a threshold. Then you can say, yes, this is a crunching point, then your business venture will be profitable. So the basic purpose of every digital economy group or MNEs or any other such player is to reach that critical mass through network effect of end users. How that critical mass is reached, how that network effect is being organized, and what is the contribution of this personal data in the value creation, all these things we have already earmarked. So I think broadly you can say this is like your data collection, then putting that in big databases, then your analytics, then it goes to knowledge bases, then you are doing some kind of data-driven decisions. And how it enhances your business is that if you know the personal characteristics of a user or a consumer, here user and consumer have the same meaning. So you can have a differential pricing. That means you can sell a product or a service to a customer for one price and to his next door neighbor for another price. So there is no uniformity of prices. And your prices determines your profit. So that we have already determined, it is on record. So that's where your data is like the big oil that is driving the entire global network. Now, turning to this, yes, this has also been discussed after we submitted our report before the OECD. So all the countries are now going through India's stand on data, and now we can sum up all the countries' views that have been come up into only 2 lines. There is not much complexity. There are only 2 lines where we can sum up all the countries' views, all the global views. Whether the role of user participation is a unique and important driver of value creation, that is one view. And another is whether the action of highly digitalized business models to source data from users is not an activity to which profit should be attributed. That means it is not forming your part of value creation. So the entire countries are just either of this line or that line. So I hope more and more discussions will take place, more and more countries will go through our formulas of how we have used that value creation, how value is created, how critical mass of end users are being reached, what are the different digital business models on different business platforms. As you know, there is a uniformity in business models. You can't compare Amazon with Uber. You can't compare, similarly, now Facebook with Uber. So there are all different platforms and different kinds of values are created. So before going into any kind of discussion, first one has to very deeply understand how the digital economy operates in different business platforms through different business models, and each business model creates its different value. So once you understand how that value is created, only then you are in a position to tax that value. In conformity with what the G20 summit has held, that it should be taxed on your value creation. So first we define the value creation, first to identify the value creation, first to measure the value creation with formulas, with modeling, and then you come to conclusion. So now, as I have pointed out, now the entire world is balancing on only these 2 views. We have not come across as yet with any third view on this. If it comes up in next week in the meeting, we have to look at it.
Yeah. So, very interesting points. Can I just make one comment in a minute, Parul? Can you hear me?
Sure.
Only one.
Yes.
Mr. Pramanik, I think it's very interesting points you made. The thing is that what we are really now talking is about value addition. By creating value, that how much value is added. And we are putting income tax on that. So in an ideal world, then we should go for value addition tax and not income tax. You know, I'm just on a conceptual level, and we can today time is a little off, but you have raised some very interesting points, and we would love to discuss with you over a period of time. But I think if we are talking about value creation, then it's a value added tax, and principles of value addition may perhaps be applied. So I'm not taking one way or the other. All that I'm saying, we as a world, all tax administrators, taxpayers, all of us have to come together and see that the life for, tax-paying community, the amount of time, energy, and I think there are some statistics also how much time is being, spent by companies on managing their tax affairs. All that thing can be at least significantly reduced if you have simpler formula, and if the countries have to, they will. It is expected that countries will act much more in a rational manner sometime. I assume for a moment. I'm not saying companies will not, but it would be good for them that, okay, here is the formula, here is the amount, here is the tax rate, here is you collect it, and you distribute between yourself. Countries, you come together and figure out, why bother me as a taxpayer? That would be my, one of the suggestion on one world, one tax. But today time is off, and grateful to you for your comments, and Soul to you too. I think maybe Soul, you might have some comment at the end, but Parul, over to you.
Yeah, I think Professor Soul would like to make a comment. So Professor Soul, why don't you make a comment? Then we'll quickly take up a couple of questions. I know we are already running late by 13 minutes, but we'll close this in the next 5 minutes. So Professor Soul, your comments.
Can you unmute? Yes.
I think you're on mute, Professor Soul.
Sorry, I'm not muted. This discussion about value and where activities take place is in relation to the allocation of profit. Sure, you may have a value-added tax on the value added, but I think in the context of the BEPS project and in the context of all these discussions about allocation of profits of multinational enterprises, it's that the profit should be allocated according to each country, where what contribution the activities in the country make to that total profit. So it's still a profit-based tax that we're looking at, I think, possibly in addition to value-added taxes. So then the question is, well, how do you attribute it? What we've argued from the BEPS monitoring group is that we think it's possible to agree on general principles, and that value is created essentially by people. It's people in the end that generate the value for a business. Now, there is a question then how you evaluate the contribution of the people and which people. Generally, it should be employees, but in the context of digitalized models, it's been argued that there are unpaid contributions by users, who are people who contribute to the value of some types of platforms. But the general principle should be, on the one hand, that it's people. On the other hand, also on the production side, there is a capital invested, fixed capital of a business. That may be a production factor. And then, as I said earlier, on the other side, realization of profit depends on sales. So one could agree, I think, that those are the general principles, but that still leaves a lot of detailed questions as to how you quantify those factors and how you weight them. And what we've argued is that if it could be agreed at a global level that those are the principles, then you could operate on a bottom-up basis to identify and quantify those factors and agree on weightings according to different business models. For some business models, as I say, users make a contribution and should be quantified as people, and that raises questions of how you quantify the contributions of users. There are other kinds of issues about quantification and weighting. Now that could be developed, but not on an individual taxpayer basis, on an industry basis and based on different business models. And we've suggested that that might be the way forward, a combination of top-down principles and bottom-up work on an industry and business model basis to agree on quantifications and weighting.
Great. Thanks a lot, Professor.
Yes, models are going through so many changes. Every day, new business model comes up, so it's going to be very interesting. Sorry for my interruption. Carry on, Parul. It's a wonderful discussion on ending, though.
Just the last point. Yeah, we can provide you the summary of our research done in Picciotto. So may not be the entire report, but if anyone is interested, we can give that on which government is basing their findings and legislation. So if you want, I can provide that.
Yeah, greatly appreciate. Thank you.
That will be really great, and I think Maya, we can reach out to him separately, and I think that will be really great and very kind of you, because
I think that will make it clear why these legislations are coming, what is the government's mind, because a lot of research has gone into that. The entire thing is not public, but the summary of it can be made available.
Great. Thank you so much. Thank you so much. That's really kind of you. I think we will end this session now. I think although we wanted to talk a little bit more about the virtual and intangible business connection, but we also delved quite a bit into the pillar 1 and the pillar 2 approaches, and Mr. Priyabrata's comments were also quite enlightening on how the government is really thinking of going ahead with the digital taxes. One closing comment from my side is that, probably the Volkswagen decision, which Maya spoke about, is going to have some very strong ramifications, because anytime any payment has to be made to an entertainer, and, there are settled tax concepts with respect to how entertainers and performers need to be taxed. And that is definitely going to create some ripples in the taxation of performers. Leaving aside the fact that the performer may not itself have a business connection in India, but does it really mean that if the payer has a business connection or an alleged business connection, then the recipient of the income will also be subject to tax in India? And what will happen to all the tournaments also that take place across the world with some intangible benefit coming to India? I think, the ramifications are huge. There's going to be double taxation issues. Countries may not really give credits for the taxes which are paid in India on account of the intangible business connection. And with the SCP coming in from the next year and the attribution principles applied even to regular business collection, I think it's just going to get more complicated. So let's just hope that OECD does come out with a plan next year, which India and the other countries also agree to. So with that, over to you, Nishith bhai, for your closing remarks, and then I think Devanshi can take it up.
I think I made the closing remarks before it was closed. I really do not want to take too much time, but thank you so much. I think Saul and Mr. Pramanik and Meyyappan, Parul, thank you for doing a great job, and everyone around. So it was very interesting discussion. I think let us continue our dialogue in the future sessions. Once again, we can get together as well.